Hi, Samantha. Hello. Hi, Samantha. Hello.
Hello, everyone, and welcome back to Samantha Uncut, where I discuss celebrity news, hot topics, reality TV, and so much more. All commentary is alleged and, in my opinion, and for entertainment purposes only. So there is an update to the Destiny versus Laberrick saga, the ongoing saga for them regarding their court battle, and Urban Bell has that update, so we're gonna get into it. So the article reads, update, Destiny Payton responds to Laberrick Williams Motion. After Laberrick's attorney filed the motion to hold Destiny in contempt, Destiny's attorney swiftly responded. In her response, obtained by Urban Bell, Destiny acknowledges that she and Laberrick had a custody agreement in which they switched custody on Sundays. She also recognizes that the protection order was not granted. However, she claims she's maintained custody of their child because of Laberrick's arrest for domestic violence. Their attorneys were coordinating to adjust their custody agreement in light of the arrest. Destiny's attorney claims it took them a week to receive access to Laberrick's bond addendum. They claim Laberrick's attorney failed to respond until after his attorney sent over a second request for a conference on February 3rd. I think that was supposed to read saying that Laberrick's attorney failed to respond to Destiny's attorney until Destiny's attorney sent a second response to his attorney for the conference on February 3rd. That's when Laberrick's attorney responded to Destiny's attorney. After the conference, Laberrick pushed to have Destiny's father involved in the custody exchange. Destiny pushed back on this because of his health. She feels Laberrick was unreasonable in this request and his subsequent motion filing. Did I not mention in my previous video that Destiny could have had her father facilitate the exchange or ask a friend to facilitate the exchange? But I mean, like, I don't want to be that person, but I mean, if you are so concerned about his health, then how come you weren't concerned about his health when you were having him dragged up and down Madison Courthouse when you had to turn yourself in for your selfie because you allegedly committed identity theft and you had a charge, so he had to go with you then. He had health concerns then. I mean, where is Tisha? Where's Stormy? Where's your friends? Can't they assist you with your custody exchange? Why isn't there another person that you put forward to assist you? Why do you only come with problems and never solution? Anyways, the article goes on to say, in the document, Destiny alleges once more that Laberrick was physically abusive in their marriage and expressed concern for her safety. Destiny is asking the court to deny his motion and instead rule that they continue negotiating their amended custody in light of the arrest. Currently, details of Laberrick's arrest warrant and bond addendum have not been made available. My thing is, they have been doing this custody exchange on and off for years, right? Since their divorce, there was no issues. So why come now all of a sudden there is these allegations and now you are scared for your safety? But yet when you guys were married, you stayed in the house that he was paying for a year and there was no issues. You had no problem staying in that house. He moved out. He actually moved away from you because he did not want to have anything to do with you. He was even the one that wanted the exchange to be at the police station because he didn't trust you. So how come now we have all these allegations and in your own divorce documents, it's alleging that you were abusive towards him? And the judge at the time threw out those allegations and did not grant you what you were asking for. I'm confused. In my opinion, Destiny is literally doing the same play that Martel has done to Melody. It is actually insane to see the similarities between these two individuals and what they're doing to their ex-spouses. It's frightening. Let's get into this response that was filed by Destiny's lawyer on February 5th at 3:33 p.m. electronically, and it was filed with the Madison Circuit Court, and it's titled "The Defendant's Response to Plaintiff's Motion to Return Child and Motion for Contempt." It says, comes now the defendant, Destiny L. Payton Williams, by and through her attorney of record, Christine D. Butler, and files before the court this, her defendant's response to plaintiff's motion to return child and motion for contempt, and in support thereof sets out as follows. One, that the defendant agrees with the allegations contained in paragraph 1 and 2, but notes that this is an intentional bad faith framing of the facts by omission of key information. Defendant avers that the plaintiff was arrested, and on January 21st, 2025, a bond condition addendum was entered permitting the plaintiff to contact the defendant only for the purpose of custodial exchange. It's also important to note on this January 21st, that was the date that Destiny filed for the protection order. I just want to note that. Number 2, that the defendant did not receive a copy of the bond condition addendum until January 27, 2025 by mail. That on January 28, 2025, having been made aware of the bond condition addendum, defendant's counsel immediately reached out to counsel for the plaintiff to facilitate custodial exchanges under the conditions set forth in the bond condition addendum, to arrange make-up days for the plaintiff, and further to come to a mutual long-term arrangement to minimize further conflicts between the parties and the need for court intervention. That copy of this request is attached here too as Exhibit A, and we'll get to that in a moment. Number 3, the counsel for the plaintiff failed to respond until after the defendant's counsel sent a second request for an immediate conference on Monday, February 3rd. Attached here too is Exhibit B, and we'll also get to that as well. Number 4, that upon returning to the office on Tuesday, February 4th, defendant's counsel noted an after-hours phone call was made to defendant's counsel's office from the office of the plaintiff's counsel. Counsel for a defendant promptly returned the call, and at 2 p.m., phone conference took place with plaintiff's counsel on Tuesday, February 4th, the same day. Number 5, shortly after said conference, plaintiff's counsel responded with an amended custodial exchange process, which required the defendant's terminally ill elderly father to facilitate the exchange. Less than an hour after the initial phone conference and prior to the defendant's counsel being able to respond to any resulting communication, plaintiff's counsel filed their misleading and bad faith motion with the court. Number 6, that upon best information and belief, defendant veers an unreasonable offer using her terminally ill elder father as pawn was made to create further delay in an attempt to justify the plaintiff's manipulated timeline of recent events. Number 7, that the plaintiff filed a bad faith motion alleging that the defendant was willfully withholding the child despite, as shown in attached exhibits, being fully aware that defendant and her counsel were actively attempting to seek a resolution to this issue and were offering make-up days. Plaintiff did so without waiting even a full hour for a response from the defendant to the offer they had made. And despite reassurances, a response would come the same day. Number 8, that in accordance with the statements made by his honorable judge, defendant's counsel believed this was an easily resolvable issue without the intervention of court, and still believes it would be so if not for the plaintiff's regretful attempt at manipulating the court. Manipulating the court record by omitting the very fact that the defendant was actively attempting to arrange for a custodial exchange. Number 9, that this is a pattern of the plaintiff's counsel refusing to respond or otherwise discuss exchange or custody issues with defendant's counsel, preferring instead to force all such discussion to occur in court during active litigation. Number 10, that the plaintiff at no point communicated with the defendant regarding exchange, despite the bond condition addendum permitting him to do so. Number 11, that the defendant avers that she fears for her safety in the presence of the plaintiff, as the plaintiff physically abused her during the marriage, that the defendant does not feel safe seeing the plaintiff at custodial exchanges, given the plaintiff grabbed and screamed at her during a prior custodial exchange, which required the intervention of a uniformed police officer. Number 12, that the defendant agrees with the allegation that the plaintiff father's custodial week would have begun on February 2nd, 2025, and points out, given the delay of response by plaintiff's counsel and plaintiff's complete lack of attempt at discussing such issue with defendant, that at this time was a blatant attempt to delay the conversation and custodial exchange of the minor child so as to justify a motion for contempt. Thus, number 13, thus defendant's counsel requests attorney fees for the need to file and address this motion due to the bad faith of plaintiff and his counsel in this situation. Therefore, premises considered, the defendant respectfully requests this honorable court enter an order denying plaintiff's motion to return child and motion for contempt, and ordering the parties to continue their already ongoing conversations on how to resolve this topic. Defendant requests in the alternative, this honorable court enter an order setting plaintiff's motion and defendant's response thereto for hearing on the same date as the defendant's petition for protection from abuse. Defendant further requests an order to be entered awarding her attorney fees and costs incurred in the response to the frivolous bad faith motion filed by the plaintiff. Defendant further requests such additional or different relief that the court deems just and appropriate. Now, before I get into some questions that I have regarding this response, I want to just show you guys the exhibits A and B of the emails that were sent to Laberrick's attorney that they included in this response. So the first email was sent on Tuesday, January 28th at 5 p.m. and it was to Laberrick's attorney. It says, would you have time over the next 2 days to have a phone call with attorney Butler, where seeking to discuss ways to alter the custody or exchange to avoid the current issues that are popping up, as well as arranging makeup custodial days for your client. If you could let me know when you would have time, that would much be appreciated. Thanks, Will J. Nelson, attorney. I guess that's the co-attorney for Christine. I think I called her Christine earlier, but her name is Christine D. Butler. So I think that's maybe like a co or assistant attorney for the case. Now, this email was sent at 5 p.m., so I'm guessing that was after hours that this email was sent, so there was no response that same day. But also, it was sent on the 28th, where the bond addendum was made on the 21st. So wouldn't the attorney have electronically receive a copy of that bond condition, so they would have known before the 28th about the condition. And so Destiny would also be notified before the 27th when the hard copy was mailed to her, that Laberrick had these conditions that were in place. Now we're still not sure what the conditions are, but based on the response in this motion, he had the condition to only contact her for custodial exchanges. And in the second email sent on February 3rd at 4:35 p.m., it's to Laberrick's attorney. It says, "I'm following up on the below email. Would you have an opportunity to discuss with attorney Butler, hopefully this week? Thank you." Now, my problem with these emails is the time frame that these emails are being sent, because this follow-up email was sent on February 3rd, knowing that Laberrick's custody should start on the 2nd. So the follow-up email for me personally, it should have been sent on January 30th if there was no response between the 28th to the 30th, because those are still weekdays. I would not expect a response from him after the 31st, because that would have been the weekend, and his custody arrangement would start on the Sunday, which is February 2nd. If you know anything about businesses, lawyers, even government offices, they typically like to send emails late in the evening, especially on a Friday, because they know that you won't have time to respond to that email during that time. And especially if it is an email that is upsetting or it's not favorable to staff or to the client or whatever, they will send that email late in the evening when they know that you are out of the office or you're about to leave the office. Now, based on this response and the allegations made from from Destiny's lawyer about Laberrick's lawyer, what I can say is that it does seem that they are playing this game of phone tag or email tag, and they are trying to cause some kind of delay, in my opinion. But at the same time, the custody arrangement should have the ongoing custody documents and the arrangement that they had in place, that should have still followed, because there was no protection order granted. So when they became aware of the bond notice, the bond restrictions or whatever that Laberrick had, he could only contact her for the custodial change. I can understand where he may not have wanted to contact her based on the fact that she is accusing him of DV harassment. And also, if she's saying that she only received a hard copy on the 27th of January, then one could say he only received a copy at the same time. If we're going to say that he did not receive a copy that same time, then we can also say that Destiny's lawyer did not receive a copy of the arrangement and the restrictions on the 27th, and that they received the notice earlier than that as well. So it can go both ways. For me personally, they are both playing games with their lawyers, and it's just getting to be ridiculous. And Destiny's lawyer saying that Laberrick is trying to use Destiny's father as a way of facilitating the exchange, and he's terminally ill and he's elderly, and they're trying to use that as a way of causing further delay. For that I can say, well, we can also say that Destiny is trying to cause delay on the matter, because one, she could have proposed someone else to be used instead of her father. Two, the custody arrangement could still have been ongoing by making alternative arrangements. And also, her father wasn't terminally ill or elderly when she needed him for other things. So to use that is you trying to use the system as a delay, and to also create a barrier between the child and his father. And she's also using the child as a pawn in this tug of war between her and her ex-husband. And I still have those questions where, if this man was so if he was so terrible towards you, then how come when the divorce was finalized, you both agreed to no child support and he agreed to pay the mortgage for 1 year, and then after that year was up, you interfered with selling the house, the process of selling the house, and then there was no problems after that, and then now you are asking for child support. And you're asking for a protection order for you and your child, but you're also asking him to pay child support. It just doesn't make sense to me, because as a woman, I would not want anything to do with a man who is that terrible to me and my child. I wouldn't want child support. I wouldn't want spousal support. I would want nothing at all to do with you. And now that her attorney have asked the court to have the motion for protection and the motion for the filing, that motion that he filed, and now this response to all of that to be on the same day, and the judge has set the date for February 13 to hear everything. Her lawyer is now coming back saying that, hey, February 13th, I can't make that date because of my daughter's state championship wrestling tournament or something like that. Wente Talk revealed that information earlier on. I mean, like, who is now causing delays with the system? All of this is just a play-by-play out of Martel Holt's playbook. Like, it's just, And for those of you who is going to come in my comments talking about, well, Laberrick shouldn't be doing this and Laberrick shouldn't be doing that, I get it. He is a petty man, obviously, and he has good reasons to be petty, because when you're dealing with somebody like Destiny, sometimes you have to be petty with a person. I don't agree with it, because at the end of the day, it's not benefiting anyone and their child is suffering. But Destiny started this. She started this war when she kept speaking about this man. She went on podcasts talking about this man, even after her divorce said that they both should not be speaking about each other. He has not said anything about her. His family hasn't said anything about her, but she keeps on speaking on him. And she started this war with him even before their divorce was finalized. She started this war with him when there was a question of the paternity of his son. So I don't want to hear it. And obviously he doesn't want to hear it either, because he's going to stay on her neck. And all he's going to say is, just like he posted, thank God for jumping on it. Period. Instead of focusing on Sunny and Moses and Melody and what they got going on, Destiny should focus on her own issues. She needs to get this situation resolved with her ex-husband, stop terrorizing other individuals, stop crying over Moses, because at the end of the day, she's going to end up just like Moses, in jail. And Sunny told her that she's on her way to jail just the same. So yeah, let me know what you guys think about all this shenanigans, this response from her lawyer, and everything else. Don't forget to hit the subscribe button, like and share, and I'll see you guys in my next video.